Good morning, everybody. This is Nick Wooten here with Consumer Trial Lawyer Academy. Glad to be back with you. We didn't get any new videos posted during the Thanksgiving holiday week due to some travel, but wanted to try to get a few things up so you could take a look at some of the rest of the issues that we discussed previously that we would have up related to the rest of the parts of the trial. So today's video is going to be, we're going to talk a little bit about dealing with crossing defense witnesses, and then we'll deal with resting, closing, and arguing damages in later episodes. So crossing defense witnesses really, if you follow the protocol, if you follow the plan, it should be relatively easy. If you think back about what we've been teaching, you should have handled every witness that you believed were going to be presented at trial as part of the direct. That way you've taken the defense's ability to tell the story the way they want to tell it. You've knocked that off. You've eliminated the drama. You've kept them from presenting a coherent case. You've put your case on in the form that you want to put it on, and you've been able to challenge their people in the way that you want to challenge their folks. And you've kept the emphasis on the defendant and their wrongdoing more so than your own client and their particular experience with this defendant. The overall portrayal being the existing case is just one example of every consumer who's ever had to deal with this sorry corporate defendant. So having said that, when they call up witnesses in this format, what they will be trying to do is trying to tell a story different than the one they've already testified to when you put their witnesses on the first time. So this will be an effort to try to resurrect the BS story that they wanted to tell the jury, but you should have already blown up pretty well. And that should be your focus. Your focus really should be on a very polite but firm attack. When I had you on the stand 2 days, 3 days, 7 days ago, that wasn't your testimony, correct? When I asked you this question, you didn't have this rehearsed answer. You had, you agreed with me or whatever the appropriate cross-examination is. Really, when you're dealing with those witnesses in that context, it shouldn't take a whole lot to really make them look very bad for trying to put those people back on and telling you story. And usually it gives you one or two chances to not beat a dead horse, but to just emphasize some of the biggest problems with their conduct and their earlier testimony, so that you have what you need to just kind of reinforce in the jury's mind one last time. We showed you how many times they lied to you. We showed you how many ways they lied to you. And then they had the audacity to get up here and try to put this manufactured story together again, even after they'd already testified that this manufactured story was just that, manufactured. So that's the way I usually handle those witnesses. And that usually moves, very quickly. Again, you don't want to be too repetitive. If you do, you want to be very focused, very quick, and just drawing a contrast between what they said when you had them on the stand and it was unscripted and they weren't prepared and they had to answer truthfully versus, spending a week with the defense lawyers at night trying to come up with some type of rebuttal story or slither through any little way they think they've come up with to try to make anything they did make sense. Usually that's kind of a fun part of the trial, because by that point they should know that you have the goods on them. You know exactly where the bodies are buried. You know exactly which documents matter. And you really can just kind of pile up on them and just sort of dare them to do that. In one of my cases, when we got to this point of the case, I asked, when they got through with the little BS story, I just stood up to the witness and I'm like, ma'am, that's just not true, is it? And she was like, what do you mean? I'm like, we went over this the first time you understand when I had you understand, and you agreed with me that X did not happen. And she's like, yes. I'm like, and then I asked, and I said, you also agreed that Y was just simply not true. Well, I'm not sure about that. Well, do you really want me to get these exhibits back out again and let's look at that again? No. That's how it should go if you've done your homework and you've done it right the first go through. They should say whatever they're going to say because they were coached to say it, and then when confronted, they have to acknowledge again that, yeah, they're just lying. So that can be fun, that can go quick, that can put sort of an exclamation point on the ending of the case. Now, prior to having these witnesses come up, you should have gone through the process of resting your own case. And even though I'm taking this a little out of order, we'll talk a minute about resting. Again, we're talking about in federal court. In general, they're going to file a motion to close your evidence. They're going to file a brief, and any judge worth their salt is going to say that I'm just taking that under advisement until we get to get through the rest of the case. But if you have any particularized issues that there's potential weakness in, you're probably better to go ahead and have those issues briefed out along with the evidence you expect to get in the case. And then usually in federal court, you'll be ordering a daily transcript, which means that your support staff or your team can be pulling the actual record citations to the evidence that, bolsters their criticism. And I point that out only hypothetically in the sense that let's say you have one point where they have honed in on and say you're weak and you don't have enough evidence to get to the jury. That's the best way to resolve that, is just to have your daily transcript, sort of highlight those part of the testimony for your team, have whoever your writer is getting that sort of lined up at night while you're getting closer to the end of resting your case. And then that way, if you do actually have to respond to it formally, you can have a one-pager you can hand the judge. It just says, Judge, here's the evidence from the transcripts that shows, the evidence in support of this particular point that they claim we don't have. And that's usually good enough. The good thing about it is the best trial judges will be on point on those types of things, and they'll tell you what their concerns are and what you should be on the lookout for and what you need to make sure you cover. And that gives you plenty of grounds and plenty of opportunity to be ready for that. But normally the resting process is pretty simple. You stand up, say you rest. The defense says they want to make their motion. Judge says either I'm going to take your motion under advisement or your motion is denied. And then it's time for them to put their case on. And then, of course, they put on their BS witnesses that we just talked about. You cross those witnesses, and then they've got to rest. As a matter of process, they will renew their motion. You'll get the same response you got before. It'll either be denied right there or taken under advisement. And then you'll go to the closings and you'll argue damages, and that will be the subject of our next video. So again, thank you very much for joining us on Consumer Trial Lawyer Academy. Appreciate all the time that you put into going through this process with us. If there are topics that you'd like for us to talk about specifically, please mention those in the comments. We'd appreciate it if you'd like and subscribe. It seems that's pretty important to YouTube, and it's corporate computer overlords that make the decisions about videos and who's popular and who's not. Again, I'm Nick Wooten. This is Consumer Trial Lawyer Academy. Thank you again for your time. Look forward to seeing you soon.